everyone. Good morning, afternoon, or evening, depending on where you are joining us from. For those of you who don't know me, I am Hannah Shea, Director of Business Development at World Law Group. This session is being hosted today by World Law Group and our Intellectual Property Group. Before I hand it over to our moderator and panel today, just a few quick housekeeping items. This meeting is being recorded, which you can see the live streaming at the top of your screen, and you may see my artificial intelligence assistant join as well. So just wanted to make that disclaimer. We will take questions via the chat. We are expecting a pretty large audience today. So if you have any questions, please do drop them into the chat, and Matt and I will monitor the chat for those questions. If you'd like to let us know where you are from, you can do so by renaming yourself, and you can hover over your video if you have your video on, which we welcome you to do so, or finding your name in the chat and hovering over that, and there's 3 dots, and you'll see a drop-down option to rename and include your firm name. So with that, I'm going to hand it over to Matt Hervey at Gowling WLG, who is one of the co-chairs of the IP group and will be moderating today's discussion. So Matt, take it away.
Thank you so much, Hannah. I have to say we normally arrange these knowledge sessions internally in the World Law Group, but this is such a pressing and hot topic that we've opened it up to become a sort of public meeting. And our topic is copyright in the outputs of AI. And I think as IP practitioners, we've been thinking about certainly patents where AI has been involved for many years now. And that's thankfully large to our guest speaker, Professor Ryan Abbott, who really spearheaded the DABUS campaign around the world when it came to patents. It is less known that there was an early DABUS copyright test case as well, which we will be discussing. But what we've seen in the last 18 months is the power of generative AI has really come of age, and it is now able to create really high quality expressive work such as text, images, film, and music. And it's also general purpose. So it's been trained often on the entire internet. It doesn't have a specific use case in mind. And it's actually becoming increasingly ubiquitous, being baked into Microsoft Office, for example. And just to underline how cutting edge this is as an issue, the second edition of my book, The Law of AI, is out in a couple of weeks. And it has a huge section on this topic. But in the first edition, which was only a few years ago, the term generative AI didn't even appear. And there were some examples of AI producing, let's say, Shakespeare sonnets, but they were very primitive and they were novelties without any commercial value. But now this is an area where the investment runs into the tens of billions or hundreds of billions. So let me introduce our expert panel. And we will, I will ask them to introduce themselves geographically by time zone. So first, from China, we have Ping Gu.
Hello, everyone. My name is Ping Gu. I'm with the law firm of Zhonglen, a top Chinese general practice firm. I'm a partner at the IP group. It's nice to meet everybody here.
Brilliant. And then moving west, we have Alla in Ukraine.
Yeah, hi everyone. I'm Alla Smorodina. I'm practicing IP law in Ukraine. I'm an attorney at law, so I'm doing this as a litigator as well. And I also recently got my PhD in law, and the scope of my interest was the license agreement. And frankly, I'm looking forward to see sui generis rights to be licensed someone. That would be the first case maybe in my practice. I'm looking forward.
Yes, we're going to be discussing. The Ukraine has a new sui generis rights for computer-generated works, which is a very hot topic. Yeah. And then west again to Brian.
Hi all, and thank you very much for having me. I'm Brian McElligott. I'm the head of the AI practice here in Mason Hayes O'Kern in Dublin, in Ireland. I have a long history and in my legal career in tech and IP law, and I've also briefly done an in-house stint as a chief IP officer with an AI fintech here in Ireland. I'm delighted to be on the panel today. Thank you, Matt.
Fantastic. And then last but definitely not least, our honorific speaker, our guest speaker, Ryan.
Well, thanks so much, Matt, for the overly generous introduction, and it's a real pleasure being here. I'm a law professor at University of Surrey in the UK and a mediator and arbitrator with JAMS in the US and UK. And just on our pre-call with this group, I learned several interesting substantive things. So I think it will be a great session.
Fantastic. Okay, well, let me give everyone a quick overview of the cases we've seen so far. So this is a chronological slide, and we certainly won't be able to tackle all of these cases in the time we've got allowed, but I want to draw out certain themes. The first theme are cases about whether the human's contribution sufficed when they used a computer or whether they used AI to be considered a human author of a work. And our key cases here are certainly the US case of Space Theatre Opera, and we'll be contrasting that with the recent Chinese case of Spring Breeze Brings Tenderness. As a parenthetical issue, we may touch on it. What is certainly the case is if you've combined multiple generative AI works, either into a film or a graphic novel, you will get some sort of copyright in the combination. The second theme is whether AI itself can be an author in law, and that's going to be the Dabus test case, which Ryan was behind. And then the third theme, which we'll move on to as a sort of separate topic, is the extent to which we have special provisions for works to be protected even if there's no author at all. And so far, there are two cases on that. One is from 2006. It's a computer-generated works case from the UK. And the other is a recent UK case where, in fact, they decide there was human authorship. So with that introduction, let's start with the most recent case in China, Spring Breeze Brings Tenderness. And Pingu, could you talk us through it a bit? And I'll show a larger images of it.
Yeah. This is me, real person, not a AI generated speaking. So what happened in this case? This is a 2023 case. So the user is actually through an online text to image AI tool created such a desirable looking girl to the right of the screen, as you can see from the screen share by Matt. So what the user has done is he has downloaded actually its own desirable Asian looking girl model into the online platform AI tool, and then entered multiple different prompts, negative prompt, and then enter what is the requirement or the parameters, the color, the scheme, so that the generated AI tool actually generated an image. And based on that, the user edited even more and entered more prompt, negative, the color scheme and everything, that more desirable to whatever the user wants the end product to be. So at the very end, they created such a desirable looking Chinese girl is different. The court actually showed different pictures and different versions where it used to have a hairband, used to have darker clothes, and they turn out to have a braid, and then have a fair skin, desirable, like beautiful, big looking eyes in white clothes. So this somebody else used this image and posted on Xiaohongshu, which is a very immensely popular Chinese online tool. A lot of people post their experiences, very popular. So the user of the AI who generated this picture using the AI tool sued the copycat who actually used it without authorization, without the copyright logo on the picture on the Xiaohongshu. So the court essentially in the decision, Beijing Internet Court reasoned that because there's actually human intellectual activities involved in creating such a picture, it reflects the user who's using the AI tool, its view on what is beauty and how it does, how the user likes the desirable end result. So there is intellectual activities involved, and this is important for the court decision. So essentially, the court said, "Oh, therefore, there is it is a copyrighted work because copyright law tends to protect, or encourage creativity." By using AI tool is no different than to use a traditional camera, right? So with the progress of technology, essentially the human involvement to create artistic work, literary work, essentially get much more reduced. For example, the court is even used an example of a camera. Like originally, the artist has to paint, right? Each brush, the strokes has to be expressed by the artist. But later, with the appearance of camera, the camera user can essentially push a button to show how you want the end result to be. Similarly, the user using AI, essentially, do not need to draw the strokes or using his brush, but he can use different prompts to change, revise, edit the final result. Therefore, the court find it copyrightable, and the author is either a human under Chinese law or a corporation through employment. So that's, yeah, thank you.
And in this case, if I understand it, the author was the person putting the prompt into the software. Yeah.
Correct.
Okay,
the court did say that the AI tool, is the creator of the software underneath. It has nothing to do with the image. The user who used the tool to create the image is the copyright owner, author.
Got it. So Ryan, would you take us through what I think is a very interesting contrast for Space Theatre Opera case in the States? I say case, it's a registration decision, isn't it?
Yeah, so the Copyright Office has had a long-standing human authorship requirement policy since the 70s, although it really only became kind of publicly known after the monkey selfies case of the early 2010s, where if a work lacks a traditional human author, they'll deny a registration on it. And this was a series of registrations, one of a group, you alluded to some of the ones earlier. It was titled Space Opera by the human creator. He submitted it to an art contest, actually, at a state art fair in Colorado, where it won. He then said, "Oh, by the way, I used Midjourney to make this," and everyone got horribly offended by it. This was early in the, kind of widespread use of the newer generative AI systems. And he had already successfully gotten a copyright registration on this when they saw statements that he had made on social media and went back and canceled his registration. And he argued, much like the Chinese case, well, sure, I used Midjourney, but it was just a tool. And I did a lot of work on this. I had a vision in mind. I very carefully wrote a prompt. I, did a lot of iterating with the prompt and the output. I edited the work after that. And the Copyright Office said, no, this was a work created by a generative AI system and therefore lacks a traditional human author and therefore cannot get protection. And he elected not to challenge the registration. But the Copyright Office's position on this is that, it's a fact by fact analysis, it's a factual analysis on a case by case basis, whether, generative AI has done so much you have to disclaim the work. And they do require that any portion of a work made by generative AI be disclaimed and not granted registration. It is unclear, though, because some of the examples we've seen, including this one, involve really a very high level of input from a human being, what they would grant protection for. So I think it really is kind of the opposite holding of the Chinese case. And, so far, everything they've gotten their hands on that they've published, they've denied registration for. We could talk about what they have granted registration for. The case is challenging it, but that's the space opera story.
Yeah, that's fantastic. And let me just give a couple of examples of my own experimentation, because what interests me is, I think it's true to say that in both China and the US, this is determined on a case-by-case basis. So no one has said, as a matter of principle, that a generative AI output cannot attract copyright, cannot have a human author. But I detect in the US position that there's a very entrenched view that these systems do not allow creative control. And I've put a little excerpt there that Midjourney does not interpret prompts as specific instructions to create a particular expressive result. So they seem to be of the view that you can't do it. My two experiments here, one, I took the prompt that was published when this Cosmopolitan cover came out a few years ago. This was created using DALL-E, and I've put the text that the artist used to generate the image. There was a little bit of subsequent editing as well. I took the same prompt and I put it into Midjourney, and I got 4 different results. I did not personally seem to have any control over the expression. And I think really the closest the prompt comes to controlling expression is words like synthwave digital art. But I think you'd agree that the original cover and my results don't show some clear expressive family from those words. And the other thing I would say is how hard it is to control what comes out. So you'll notice that the prompt says a swagger toward the camera. And of my 4 images, only one of them has the figure walking towards the camera. So these systems really don't understand language very well. And my second experiment is to use a single letter as a prompt. So the 4 images on the left, the prompt was the letter A, and in the 4 images on the right, the prompt was the letter B. So no attempt to control expression at all. And I got very detailed artwork out, but the expression was not under my control at all. So for my money, I suspect if it came to a UK court, we would have a similar outcome in terms of whether there's human authorship to the outcome in the States. But Brian, Alla, do you have any other instincts about your jurisdictions?
Yeah, I think I'd be kind of in a similar sort of a vein to yourself, Matt. I suppose the first thing to note is that in Ireland, we don't have a system for registration of copyright, so there would be no office decision. So it would be decided by the courts, and then the courts would begin by looking at it from the perspective of Irish copyright law, and it's something we're going to come on to in a moment. But suffice to say, I think the ultimate argument would end up being a European law type argument. And I think the most interesting thing maybe that's coming out of this is, would it be this type of fact-by-fact, case-by-case analysis? Or would they introduce a principles type analysis, and maybe around originality they might? I'm not saying they would, but they might. It would be a brave decision, I think, because you'd be kind of saying all of this technology is off the books from ever being, somehow manipulated for the purposes of creating original works, but I don't know.
Just on that, I mean, two points. First of all, under EU law, it's clear that originality is a person's own intellectual creation. So they've definitely made it a human issue, originality. And the other is we do have that one case from the Czech Republic. There is no image available of what it was, but that's the first time it's actually been heard by a member state. And in that instance, a prompt along the lines of two hands signing a contract, that was not enough to give you human authorship. Alla, any other perspectives on this issue from Ukraine?
Yeah, you're right. The originality is a key issue in Ukraine under Ukrainian law as well, because originality is, let's say, skill of human being. So by default, output created, generated by any computer program has no originality. With respect to registration, copyright registration is voluntary in Ukraine, but this is a good question because there is no expertise. If person submits any work, let's say image, for registration, the registration office does not provide any expertise to understand in what way it was created. So the registration given kind of by default, assuming that this is the work created by the person who submitted for registration. As far as I know, there is no case as of now with respect to registration, the output created by AI versus is copyrighted, right? Is copyrighted work. So we'll see.
Okay,
one more notice that, but by default, output generated by computer program, because Ukrainian law doesn't operate with term IE here, is granted by sui generis right. It's by default. If non-original, it has sui generis protection.
Yeah, we'll come on to that after one other topic. But yeah, thanks for leading it in there. So the last bit of this session, this part of the discussion is Ryan's test case, which is a different issue. It's not, is there a human author? It's please assume there's no human author. Can the AI be an author? Ryan, do you want to just talk us through this a bit?
Sure. How long do you want me to talk about it?
5 minutes would be lovely.
Sure. So, well, yes, it is a different author, but a different issue, but also the same issue. You know, I've always viewed the case more about whether or not an AI generated work is copyrightable in the United States. And the way one gets at that, because it's not an infringement case, is by dealing with the authorship question as well. So this
Ryan,
image,
can I just, oh, sorry.
Oh yeah. So this image it kind of substantially predates the large language model releases of a few years ago. And it was made by, a very old generative AI system involving just a series of neural networks that interact with each other in complicated ways I could explain if anyone's interested. But by being prompted, not by text, it generated this output. And the way I would phrase it is kind of in the absence of a traditional human author. Excuse me. In the same way that Matt put the letter A into Midjourney when something rather incredible came out, it wasn't that people weren't involved in making this system or generating this output, but no one did anything that would traditionally qualify them to be an inventor. If I gave the letter A to a human author and said, make me an image, and they came back with something, I wouldn't be listed as the author on that thing. And so we filed for this work for registration with the US Copyright Office and listed the AI as the author. And the reason we did that, was a fewfold. It wasn't to give an AI a right or any kind of acknowledgement, right? I mean, an AI isn't a legal person, so it couldn't own anything. And an AI could care less about being acknowledged. It was to simply disclose that we didn't have a traditional human author. And also, if someone is to own a work made without a traditional human author, and we don't have Section 9.3 of the CDPA in the UK, on what basis is that? And so to have a clear chain of title. And also, for a moral rights perspective, to be accurate that, well, someone didn't make this, traditionally, because this isn't the world's most exciting piece of artwork. But if it was a bit like space opera, I think it might be, morally problematic for human authors for me to say, I make everything that comes out of Midjourney myself, if I'm really not doing it. So the Copyright Office rejected this on the basis of their human authorship requirement, which had never been challenged in court. It went through 2 rounds of rejections. I think they really took their time doing this for whatever reason. We filed it to the district court. We lost. It's now up to the DC Circuit Court of Appeals, which is the intermediate federal court, and we have oral arguments scheduled in September. Now, what is very interestingly happened, our U.S. Supreme Court is going through a very interesting period of history where it has really disrupted a lot of established legal norms that have been present for a long time, many of which those of you who don't follow U.S. law will have read about in other contexts. But one of their most dramatic decisions was to do away with this concept of Chevron deference, which was where U.S. courts basically defer to administrative agencies for their interpretations of statutes, and where prior to Chevron deference going away, the court was, perhaps very likely to say, well, the Copyright Office says this, therefore that's that. But now the court is really looking at this entirely de novo. And although the Copyright Office says, well, there's this implicit human authorship requirement in U.S. copyright law, there's nothing explicit in the US Copyright Act that says you have to have a human author or really anything about that. In fact, like China, as I've recently learned, US copyright law has allowed non-human authorship for over a century. You can have companies be authors. And when you have a company be an author, there's no requirement that you have a human being disclosed as having done anything creative. So to the extent that there's a claim that there's some implicit human contribution to originality, that really is nothing statutory. That is just dicta in cases where human beings happen to be authors. And the Copyright Office then sort of says, well, but copyright law is designed to promote human creativity. And not so in the United States, where the Supreme Court has repeatedly held Copyright Act in America is to promote the generation and dissemination of creative works, and benefiting an author is a means to an end. And so denying protection carte blanche for any computer generated work is a major disincentive to people making and using AI to make and disseminate creative work. So that's the case, and that's kind of what's coming up for it.
Yeah, and you touch on potentially a cultural difference between maybe common law countries where copyright has been, at least in origin, more of an economic right, and it started with publishers, not authors, at least in the UK. And what is apparently more of a civil law tradition, or at least in France, where it's about human dignity and about moral rights. So we may see a difference, a philosophical cultural difference emerging on whether these works should be protected or not.
I see
yeah.
Olivia posted an interesting question, if I can address it right, saying that both of these had involved some kind of changing facts. Well, this was it, right? So in Space Opera, the author didn't disclose the use of generative AI. The Copyright Office had never, there was this human authorship requirement, but it was buried in the compendium somewhere. No one other than an expert on AI generated works would know it existed. Nowhere in the form did it say, disclose if you've used computer generated anything. Now the form says that, right? But at the time, very unclear that he had to say anything about it. And on the Davis case, no, the Copyright Office has taken the position that they're disputing the facts now for the first time. The work was claimed as being made without a traditional human author. Another, one of the arguments we're running is, well, either the AI is the author because it factually made the thing in the way a traditional human author did, or Thaler is the author because he had the work created. He exercised control over the work and he used the work. And the Copyright Office has said, well, you said the AI made the thing. And we said, well, yes, and it did. But still a person made and operated the AI to make it. And so if you want to expand what it means to be an author from I put pen to a paper to I typed the letter A into Midjourney and out came an image, that's also an option for the court, but consistent with how the work was made.
Yeah. So we're going to change topic ever so slightly. It's all related, but this is a question about whether different jurisdictions have actual provisions where there is no human author to have some form of protection. And I think it's fair to say that the UK has the earliest express provision along those lines. So the 1988 Copyright Act included section 9.3, which is for computer-generated works. And by definition, these are works where there is no human author. And this was introduced before generative AI was a thing. I have heard, but never seen evidence, that it was things like weather maps produced by computer that people thought should be protected. Now, until last year, there'd only ever been one case, and that was the first case on my slide from 2006, the case of Nova, which was a computer graphic of a snooker table or a pool table, I think, which was part of a computer game that was in a pub or a bar. And that was a conventional form of program. And it was held by the court that there was no human author, but the deemed author was the programmer who had written this. And there was a case that maybe it was the user of the game was actually the deemed author, but it turned out that it was the programmer. What's interesting is there's been a recent Court of Appeal decision on the second ever pleaded case on this basis. Both sides pleaded that it was an instance of computer-generated works, but they were debating who the deemed author should be. But somehow, by the time of the Court of Appeal decision, the case had become one of human authorship. And the person who designed the user interface, the programmer, was in fact a human author who had directly controlled the expression of the output. And the aspect of it being a computer-generated work had fallen away. What has also happened informally is one of the judges involved in that case, a Court of Appeal judge, Lord Justice Arnold, has very generously given his views in public talks on this provision. And he, although he obviously needs a case before him to actually determine this for sure, he has raised issues with the fact that the way our Act is structured, computer-generated works are a form of original work. And under our harmonized law, even though we've left Europe, our law at the moment is still that originality requires a human, because it's the author's own intellectual creation. So he has raised concerns that this provision is actually unworkable, even though it was expressly written into our law in the 1980s, and clearly there was some intention to protect some sort of work. So that's where we are in the UK. I think it's fair to say that the UK law was then essentially rolled into the law of other countries. And those are, as far as I'm aware, Ireland, India, South Africa, Hong Kong, and New Zealand. And we're lucky to have Brian on the panel who can talk about it from an Irish point of view.
Thanks very much, Matt. Yeah, as you say, I think we were inspired in our Copyright and Related Rights Act of 2000 with our own concept of a computer-generated work from your own 1988 Act. A slightly different flavour of it. A computer-generated work in Ireland is a work that's generated by computer in circumstances where the author of the work is not an individual. So, you know, specifically making way for a deemed author scenario, like you've been discussing. And in this case, the deemed author is the person by whom the arrangements necessary for the creation of the work are undertaken. That one alone, I think maybe we might come back to in a while, because it's an interesting definition to try to think of in the concept of Gen AI in particular. But however, this whole concept of originality comes back to haunt us in Ireland also. Because of that very kind of famous InfoPact decision, which says that, you know, originality is equal to the author's own intellectual creation, what you're left with is a scenario where you require an author's intellectual creation, but you have no author. You do have a deemed author, but what you have is a little piece of Irish copyright legislation which is not harmonized with that EU position. And so to go back to what we were talking about at the beginning, if a test case were to be brought in Ireland, and we have seen none so far, how would that provision fare? And I think ultimately, against that originality test, which has been around for quite some time, it would be challenging to see how that provision would stand up. So there probably would be some very winding process of a case like that going through Irish courts and up to the European level. But ultimately, it's difficult to see how it will be decided any differently, and that provision just doesn't seem compatible, which is as what Justice Arnold has said.
Yeah, and that's in a country which has left the union.
Yes.
He doesn't think it works, and so, and the only direct comment I've seen is I think there's a commission report on the copyright protection of computer programs, and they did complain in that report that the UK, then a member state, because it protected computer-generated computer programs, was actually beyond the harmonized position. So, yeah, I don't think the EU is sympathetic to the idea of computer-generated work. So I would doubt the CJEU would like it. So, Alan, will you tell us about the latest member of this club, Ukraine, which has a brand new form of protection for works without human authors generated by computer?
Yeah, right. Starting from January last year, Ukrainian law on copyright and related rights was significantly, let's say, amended. And as of now, there are two type of non-original works, and they protected by sui generis right. And now law provides for definition what is this non-original output or work created by computer program. By the way, law says computer program. It doesn't say AI or something like that. So it's quite wide definition.
Same in the UK and Ireland, yeah.
Yeah, and the law says that non-original work created by computer program must have two requirements. First, it must differ from other alike works. So it's not about originality, but distinctiveness. Two similar objects may not have sui generis protection.
So our third topic is the contractual approaches which are being seen in the marketplace in the light of, at best, the uncertainty of IP in these outputs, and at worst, there being no IP in these outputs. So, Brian, do you want to give me your sense of how the market's reacting in terms of contractual terms?
Yeah, sure. I think maybe the first thing to say is that the market has massively changed its position from, let's say, January 2023 or November 2022, when Gen AI first exploded onto the scene. And back then, you could have seen some conditions that might have said, you know, the provider of the technology also owns the outputs. But things have migrated from them to roughly, I think now where the position is that there's an acknowledgement that both the prompts and the outputs belong to the customer or whoever is inputting the prompts and receiving the outputs. There seems to be an acknowledgement that there is at least the risk that there is no intellectual property in those outputs. You will see assignment clauses, but you will also see backup licensing clauses if the assignment fails. You will also see in some other of the contracts acknowledgements, even let's say via the warranties, that they cannot make any warranty with regard to the originality of the work, leading to, you know, inferences about copyright. And even many of these across different providers and platforms, they vary slightly. Each of them in due course since that time, 18 months, 2 years, they've changed their position slightly. Some of them gave no comfort whatsoever at the beginning with regard to IPR infringements. Some of them now are giving some comfort. They're making some statements with regard to maybe the use of the machine. They might be covering or giving protection with regard to that, but not necessarily the outputs. Everything with regard to the output is on the individual, which in fairness does make sense. One very interesting thing I actually only saw in the last couple of weeks is a niche application of Gen AI in the residential property due diligence space. It's a company called Orbital Witness in the UK, I think it is, and they are offering professional indemnity insurance against the outputs in the context of using those following the diligence. Now, I have no details whatsoever as to what's covered, what's not covered, and what the outputs and the diligence looks like. But again, let's say in a very narrow application of the technology, you can see that the market is moving again. So I think that the main conclusion is that the market is moving a lot. And there's a recognition coming through in terms and conditions over the last while that the position with regard to copyright in particular is weak at best.
Yeah, I mean, I think the classic wording one often sees is the user owns any rights or rights, if any, in the works, and then warnings that there may be no IP. I think other things we see is some have a default license back to the Gen AI platform, maybe for training, or maybe because they have a public gallery of outputs. And I think the oddest thing I've seen, or the most challenging thing, let's put it that way, is an attempt to create some degree of exclusivity, even without IP. But I think the most people are able to do is to say they won't generate an identical image for another user. But I think it's important that they're very clear about whether that gives them any rights against third parties, which, as I see it, it wouldn't unless there is, in fact, IP.
No, and I think
Brian,
it's a very good,
yes,
it's a
sir.
very good point about the third party rights. I mean, at the end of the day, at best you have a contractual arrangement between you and the provider of the service. To the extent anybody else receives something similar or maybe makes allegations of infringement against you for using the output, you're kind of on your own, or indeed they're on their own, because if they're taking the output of a machine as well, what copyright do they have to assert? And I agree that the exclusivity piece is quite odd, given the
Yeah,
nature of
yeah.
these machines.
Ryan, did you have something to say? You popped up there.
Oh, did I? No, that seems right. I mean, potentially, maybe an interesting claim against someone else using the same platform to generate something. But yeah, if someone's using a different platform, hard to see if there isn't IP how you could go after them for that. And let's see what else. Yeah, and some services do require someone to pay for an exclusive license or an assignment, or require someone have an enterprise license or something of that nature. So, not a big deal for me using it to make slides for presentations, but for
Sure.
creatives who are using this in music and movie studios, or because they're professionally creative. Yeah, these terms of service could be a big deal, and one has to look closely at them.
Yeah, I think one of the tricky ones is secrecy, as it were, because at least one of the major providers, unless you have an enterprise license, they will put any image you create and make it publicly accessible. So if you're making mood boards for internal use, you really want to make sure you have the right license with them to make sure it is in fact confidential to you. And you've raised the issue of the downstream use. So as you've said, if it's your slides, you're not really bothered about IP. And I would agree that where the use of the image is actually public, like an ephemeral or a viral advertising campaign, maybe IP isn't essential from a business perspective, and maybe that justifies the use of generative AI for the sort of cost savings and speed it may allow. But I do think there is an issue in the creative industries to figure out how they actually address this. And I think it's very important that people aren't using boilerplate contract where you've warranted that it's original, that you are assigning the IP or you're licensing the IP, because it simply may not exist, and you don't want to be in breach of that because you've used generative AI, maybe with common understanding that that's what's going on.
So it was before my professional time, but my understanding was that the 1988 amendments to the CDPA to protect computer-generated works came about from lobbying from the British Computer Society, saying that the technology was almost there to make this sort of thing common, and if we didn't have some clarity around the rules, there was going to be this widespread confusion around what people could and couldn't do. And so it's interesting in this, they were at least 30 years ahead of their time on this, but in the States, we've now got that. But it's interesting now with your Justice Arnold comments that we still seem to have widespread confusion in the UK. So, yeah, although it's still, he is perhaps a bit of a skeptic of AI generated content, as he was also my Court of Appeals judge in the Dabis case. But, it does seem strange to me that you would have Parliament going so explicitly protecting this sort of thing and then have some uncertainty or confusion around whether it applies at all. But we'll see what happens.
I think the confusion is about whether they've written the law in the right way.
Well, indeed, but still.
Yeah. And if they haven't written the law the right way, how can you be sure their intention was? It's a tricky situation for sure.
Yeah.
Okay, so our last topic is policy direction. If we think any countries are going to follow suit like Ukraine has recently and introduce any new laws in this space. I did notice that the AI PPI voted unanimously in 2019 that copyright protection was desirable for computer-generated works or AI-generated works. And the UK IPO had a consultation in 2021, 2022. So before the whole generative AI wave, and they did look at our laws on computer-generated works. They decided to maintain the status quo. And they said there's no evidence it was harmful, and at that point, there's only ever been one case, so fair enough. They also acknowledged that AI was in its early stages, so proper evaluation was not possible. So they didn't propose to do anything because of the risk of unintended consequences. And I think, Ryan, there was an inquiry by the US Copyright Office started in August 2023.
Yeah, and they kind of doubled down on their position, which was, copyright is designed to protect, a traditional sort of human creativity. The human authorship requirement is appropriate. We're going to create, guidelines and a disclaimer in our forms to make sure people are being prompted to disclose this sort of thing. And, in every instance where this question has come up, the Copyright Office is held against extending protection. Yeah, the U.S. Congress and state legislatures are very interested in these issues. Kind of the two more perhaps pressing ones have been someone's, publicity rights, their name, image, and likeness, because music and movie studios in particular have kind of recently gotten very concerned about the use of their creatives in stuff. So you have, Tennessee recently passed kind of a no fakes act, or the Elvis Act. Sorry, the No Fakes Act was the federal one. Kind of prohibiting certain uses of synthetic content in the U.S. I think your past panel on, whether you could train AI on protected content is the next. Yeah, but protection of the outputs, is still a big issue. I think it's kind of a little less of an issue for people than training and synthetic content, but it is very much on the agenda. So I do think we are going to get some activity, and I think the fact that China in particular is protecting this sort of work and the U.S. isn't, the U.S. may kind of geopolitically sense that this is a disadvantage in its AI industrial strategy and be prompted to do something about it. But we shall see. There are people with interest on both sides of this.
Very, very interesting. Ping, can you respond to that? Do you have any sense of whether China might formally allow protection for these sorts of works, or what the temperature is there and the direction of travel?
Well, we definitely see as in the court decision, the judge actually said that the underlying reasons for copyright protection is to encourage creativity. So the technology improved, but the human involvement or their intellectual work should also be encouraged. So I think we see this in line with the general environment in China, where we encourage creation, creativity. I'm not be surprised if there's any the Law Society are started voicing their intention on this. I think I'm not be surprised if something come up very soon. So that's my take on this. Thank you.
Thank you, Brian. Any view from Ireland, which has always traditionally supported the arts?
Yeah, absolutely. I think there've been consultations, kind of anecdotally rather than anything very solid here, and very much so, let's say, looking into the consequences and wanting to do something about it. But kind of again, at the end of the day, we will be beholden to what happens at the EU level also. And my understanding from speaking to people who are heavily involved in, let's say, drafting the AI Act, and let's say all of the back and forth with the copyright provisions regarding the training of models, was there was no appetite whatsoever at that table to open up arguments on copyright and originality in the context of the negotiations. And they felt they had enough problems on their plate, and that this particular one was maybe not the easiest one to take on board in the context of those negotiations. So I don't think there's anything planned anytime soon.
Yeah. I mean, I think it is it is a very complicated economic question, whether copyrighting these works would stimulate creativity, would stimulate innovation, whether they become worse competition for living artists if they do attract competition, if they do attract copyright, because they are equally enforceable and very equally valuable in terms of business, or if it's worse if they're public domain, so that people have many cheap alternatives to the work of living artists. Now, Alla, if you're If you have an insight into why Ukraine did introduce its sui generis right, it would be great to hear your thoughts on that.
Well, I just want to say that speaking about Ukrainian new provision in law, but there was a long way made by Ukrainian researchers and practitioners and whatever to understand what would be the best option to protect this non-original work, because as far as I understand, it's not normal when there is an object, there is an output, and it has no legal status, right? So one day you should, it's a problem, and one day you should understand how this legal gap might be covered. And there were two options: copyright or sui generis. And we'll see, maybe in a few years, we'll see the result, how it works. Was the sui generis the best option? We'll see. But now Ukraine, as a candidate to EU, and it has numerous obligations with respect to future implementation of norms. But as of now, there is a draft law on AE. And of course, it contains not only intellectual property issues. There are a lot of issues which might be covered, which needs to be covered by this law. So I believe, for example, there are a lot of discussion about human rights, about ethical use of AI outputs, a lot of different points of view. But now I believe that this topic will be developed very fast. We'll see the result.
Well, thank you. We're out of time now, so I would love to thank our panelists, so Pingu, Alla, Brian and Ryan, for such a brilliant and insightful chat. And I'm sorry to our audience we weren't able to deliver it in one go, but we hope you enjoy the edited version. So thank you, everyone.